is open discrimination. It's no different than the Jim Crow laws that we had here in the South.
Well, now it is on to the next phase of the fight over North Carolina's so-called bathroom bill. The federal government has told state lawmakers the bill violates the Civil Rights Act, also Title IX. It prevents local governments from passing their own non-discrimination laws, and it requires transgender people to use the bathroom assigned to the gender listed on their birth certificate. Well, the Justice Department gave the state until tomorrow to respond. Now, earlier this week, the governor of that state, Pat McCrory, said that deadline would be met. But now, the Speaker of the State Assembly says the deadline will come and go with no response. Attorney Pate is joining us now. Paige, good to have you this morning.
Good morning, Victor.
So, Paige, let's start first with this declaration from the DOJ that this is illegal. The Assembly, the Speaker of the State Assembly says this was a duly passed law and this deadline will come and go. Why is it being considered illegal?
Well, we've had a political conflict about this law for a long time, and now we have a direct legal conflict. The Department of Justice is saying that this law, as it's currently written, conflicts with federal civil rights laws. There's Title VII, there's Title IX, and there's violence against women. When federal dollars go into a state, the feds are obligated to make sure that that money is not used in a discriminatory manner. So the Department of Justice is saying by this law, for institutions like the University of North Carolina and all of your state school systems, if you require the use of bathrooms as written in this particular state law, you are violating federal civil rights litigation.
Okay, so the feds have set this deadline of tomorrow for a response. The governor says there will be a response. The Speaker of the State Assembly says there will not be a response. Right. If there is no response, then what?
I think it's clear from this letter that the Department of Justice will take it to court. Okay. We know there's already one lawsuit that's been filed by the ACLU and some other individuals challenging this law. It is possible the Department of Justice could join that lawsuit or file a separate lawsuit. But the governor, even if he wanted to, can't undo this law. He can't take it off the books. He can't, take it back or strike it out. There has to be a resolution in court. While the Department of Justice...
Or legislatively.
Or legislatively, but there's just not time for that, and there's not the interest for that. I think the folks in the State Assembly have really dug in their heels and said, this is our law, we're going to keep it on the books. So if it's going to be changed, I think it has to be done in court.
Now, typically when there's a challenge to a state law from the feds, the state's attorney general would come in and defend it. But in this case, he is also running for governor of North Carolina, has said that if challenged, he will not defend it. So who then steps in to defend the law in court in the absence of the attorney general?
Well, that's a great question. It's an unusual situation because that is the attorney general's job, for the most part, is to stand in, defend our laws when they've been challenged. I think the governor here will do like governors in other states have done when there's been a political conflict. He can appoint a special counsel, a lawyer to represent the state, to go into court and to litigate this particular issue. But I think the governor may use this litigation as a way to resolve this, as a way to come to some settlement with the Department of Justice so that they can stop the litigation, they can keep the funding in place, and maybe somehow also satisfy the State Assembly.
All right, tomorrow is the deadline. We'll be watching closely. Paige, thanks so much.
Thank you, Victor.
Anna?
Well, the